Good afternoon. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, Judge of your Webb County Court at Law 2. This is the family law docket for Tuesday, June 2nd, 2026. The time is now 2:02. Court is now in session. Assisting us today are Cecia Rodriguez, Court Administrator. Mr. Uatlo Cuellar is the Court Interpreter. The Court Coordinator is Ms. Cynthia Flores. Video conference co-hosts this afternoon include Ms. Rodriguez, Ms. Noriega, Ms. Ramos, Ms. Cuellar, Ms. Rivera, Ms. Lozano. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court, because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There's no smoking, no chewing gum, wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person and then those online, as measured by your login times. Ms. Flores.
So the first case in person is Attorney Elisa Marsoto, page 1, number 1.
Raul Agustin Gonzalez versus Lizeth Lopez Gonzalez, cause number 2015 CVG 561C3. Court marks Ms. Soto present in person. She's the court's appointed guardian ad litem. Court marks Mr. Juan Garcia present in person. Mr. Ruben Arce, are you present? Court finds Mr. Arce not present in person, not present by video conference. Speak into the microphone and tell the court, are you Raul Agustin Gonzalez?
Yes, Judge.
Welcome to court, Mr. Gonzalez. The court marks you present in person. The person to your right is your lawyer. Mrs. Gonzalez, speak into the microphone and tell the court, are you Lizeth Lopez Gonzalez?
Yes, Your Honor.
Welcome to court, Ms. Gonzalez. Court marks you present as well. Mr. Garcia?
I believe there's no announcement in the alarm.
That's correct, Your Honor. So I have been speaking with a counselor on this matter, Ms. Nora Villarreal. And we both addressed some of the inconsistency in the child's statements with our interviews of Camila and the records that we've received from Border Region. At this time, however, because of the diagnosis that has been given to Camila, and because the counselor believes it's not appropriate at this time to reintroduce father to his visits, we want to leave the status quo. I did speak with Ms. Villarreal, the counselor, and she wanted the child to be evaluated because she believes there might be some other mental health issue in the daughter that's causing these allegations to surface in an inconsistent manner. So because of that, and because of the counselor's recommendation that at this time it's not in the best interest of Camila's stability to reintroduce father, we want to leave the status quo, which is continue the counseling until the counselor, Ms. Villarreal, and I can address family reunification counseling for dad and Camila. And I did not reach out to Mr. Arce, but I believe Mr. Garcia, and he conferred on my recommendation, and Mr. Arce does not have an objection to continuing the status quo.
Mr. Garcia?
That's correct, Your Honor. And currently he's in County Court 1.
So to be clear, Mr. Garcia, the status quo, would that change the orders in the final decree of divorce?
Closer to mic, counsel.
It could change, Your Honor, in the final orders, depending on the outcome.
Well, it
Right,
might, but my question is, because look, we're here for a final hearing on a petition to modify. If the request is to keep the status quo and the status quo is divorce decree, then Mr. Arce isn't here to present his case. There being no evidence, I deny the request and you keep the status quo.
So the status quo right now is the court had suspended. I don't know if there was temporary orders that were issued before that hearing. So right now the visits are suspended.
So keep the status quo in the temporary
Correct.
orders.
Yes, Your Honor.
Understood. And what was the recommendation of Ms. Villarreal? What is the time estimate?
I would think another month, Your Honor. I don't know if the child has seen anybody else. I know she's been seen at Border Region and she's been seen by Ms. Villarreal. I don't know if there's been any other recommendations, but I would think a status hearing in 30 days would suffice. The child is under medication now, so I think that would help try to start the family reunification visits.
Remind the court the number of children before the court?
1.
age,
15?
13.
13,
and gender.
female.
All right, well taken. Let's do two things. I know the request is 1 month. We don't do statuses, but we could give us a final pretrial hearing in 30 days and a final hearing in early to mid-August.
Final pretrial, Your Honor, will be July the 7th at 2 p.m.
All right,
And final hearing August 13th at 2 p.m.
and that'll give you some full and final orders before the commencement of the new school year. All right, Mr. Gonzalez, do you have any questions for the court?
Inaudible.
Into the microphone?
I have nothing for the court, Your Honor.
All right, Ms. Gonzalez, do you have any questions?
No, Your Honor.
I wish you both very well, but more importantly, I wish your daughter all the best. Good luck to all.
Thank you, Judge.
Thank
Thank
you,
you,
Honor.
Judge.
That is all for Mr. Garcia.
Good to
Yes.
see you, Mr. Garcia.
Same here, Judge.
Next case from Ms. Soto, page 5, number 12.
Angel Benavides versus Jocelyn Liendo, cause number 2026 FLA 90C3. Court marks Ms. Soto present in person, Mr. Rodriguez present in person. Good afternoon to both.
Good afternoon,
Good
Judge, Your
afternoon,
Honor.
Judge.
Speaking to the microphone and to the court, are you Jocelyn Liendo?
Yes, Your Honor.
Welcome to court, Ms. Liendo. The court marks you present in person. The person to your right is your lawyer. Angel Benavides, are you present? Court finds Mr. Benavides not present in person, not present by video conference. This is an entry of temporary orders. Mr. Rodriguez, Ms. Soto?
Conferred, I prepared the orders based on what was read into the record on our last hearing in April, on April 1st, I believe. Actually, March 31st. And there was a comment made or remarks made during that temporary orders hearing that wage information was going to be submitted to me for calculation of child support. So that was not actually directly addressed, but we said that we're going to discuss amongst ourselves and then include that in the temporary orders. My number coincides with the Attorney General's number, and the child support should be $1,101 based on Mr. Benavides's wage and pay stubs with the Army. And then there was also discussions with safe haven language. That was also included. I know the things in dispute right now are the child support amount. As Mr. Benavides wanted it to stay at the $500 he was providing to my client before the filing of this petition. And the inclusion of the HEROES program, which was not addressed before Your Honor. The HEROES program apparently helps deployed military with any modifications of child support. And I don't think there's an objection to HEROES becoming involved, as so long as Ms. Liendo gets to object to any modifications filed by that program.
Mr. Rodriguez?
Yes, Judge, in the temporary order proposal that I submitted, I believe it has that language. So we're not in objection as to the current amount, but we did want language for the HEROES program to have the ability to, I guess, modify that amount. And I believe it includes the language of reserving the right to object to it if necessary. But we are requesting that office handle child support, Judge, through that program.
What office?
Attorney General's office.
Oh, well,
So, and then the only concern that was raised before Your Honor on the March 31st, he's deployed. The Army is not going to withdraw funds and send it to the Attorney General's. So I had a concern about that. What exactly is the HEROES program going to do? It doesn't do the modifications because the order said he has to send through Zelle.
Court marks Mr. Schamberger present, not on this case, but certainly on this docket. Mr.
Yes, Your
Schamberger,
Honor. I'm not on this case, but I know they were talking about some things. I can answer some questions if you want, but
would you share with us, or I guess put on the record, any information that you may know regarding the HEROES program and the Office of the Attorney General?
I don't know about the HEROES program. I do know for all service members, the withholding orders, whether they're deployed stateside, they go to DFAS. So it's the same accounting group for all the branches. So I don't think there would be an issue with sending a withholding order there. Now, it may affect allowances and things like that. But that's something that we never have jurisdiction over anyway, because they'll change his allowance based on support orders that are set.
Does that shed any light?
I mean, just for efficiency purposes, Your Honor, and because my client has not received any child support since March, we would just prefer that the court's ruling state that that actual payment has to be made through Zelle, and we'll give him credit for that.
Well, Your Honor, we do have an active case, so we were going to file a notice of assignment. So when we have that notice of assignment, the payments should go through the disbursement unit. So that we would request, again, on this case, we would request that, but we're not actively participating in the case. But when we have those cases, we file these notices of assignments once we get the private order, and then the money should be redirected to the disbursement unit. Because it
Right.
keeps the accounting a lot cleaner.
All right, so let's take this, as if I understand the full range of issues, Ms. Soto and Ms. Rodriguez, there's three issues pending before the court. Ms. Soto, you believe child support for purposes of temporary order should be set at what amount?
1,101.
Any objection, Mr. Rodriguez?
No, just not to the current amount.
Is the current amount 1,101?
Yes.
All right, so that is ordered. The second thing is the HEROES program. That is your request, Mr. Rodriguez?
That's correct, Judge. And another matter before the court is that program, I believe, works closely with the current situations. And I believe, well, my client's expecting another child, which obviously changes the calculation again, I believe within this month or next. So that's why we're urging this from the court.
What issues does the HEROES program resolve, and what does that have to do with a pending or impending pregnancy?
They work with paternity confirmations, I believe, is what I gathered from the website. So based on that, they'll confirm paternity issues and do certain calculations.
And Judge, I don't,
And the inclusion of the program benefits the child how?
It keeps up with the temper or the resources as the parent has, because with the military, it changes, Judge. Like right now, he's currently deployed, so they get stipends, upfront stipends, and they're obvious that income obviously doesn't reflect the total year income. And also, once they're divorced, their allowances significantly decrease. So they keep up with all of that.
So the I'm just trying to understand this. So the HEROES program takes a judicial order and then modifies the obligation of the parent based not on the court order, but based on their allowances
Yes, Judge.
outside of this court.
Yes, well, it's based on the court through I believe they get authority through the court order.
Yeah, it's through the attorney. I looked it up real quick because it is through the Attorney General's office. It just looks like a specialized program where we have caseworkers specifically for military members or service members that helps them, get copies of orders and make sure that what's supposed to be deducted is deducted. Because when they separate, if they're getting like VA or retirement, we can't garnish their VA benefits. So some people don't know that they have to send it in. So it sounds more like a specialized help program. It's not necessarily like, I don't think it has to be court ordered into. I mean, I've only just read a little bit of it from our website.
Mr. Schoenberger, from hearing what Mr. Rodriguez was saying, it sounds like that program is able to modify the judgment, but hearing it from you, it sounds sounds like it's an administrative help to service members, not a judicial enforcement or anything.
Correct. Correct. We can't obviously the court order is the court order, and until it's changed by further court order. But Mr. Rodriguez is correct. Once a divorce goes through, the allowances that he currently has will change. So it just depends on how the court wants to handle that. And we can look at, because if we get the LES from him, we can see what the salary is and we can see what the allowances are. Because every duty station is going to have different allowances depending on what he's doing and where he's located.
And Ms. Soto responds, what is Ms. Liendo's position?
so again, Your Honor, I don't think it needs to be part of the court order if it's administrative help, and I certainly wouldn't want to agree to language that's going to leave or limit our ability to object to any modifications or arguments as to what the child support should be for the child before the court today. I don't have any objections to them becoming involved later on if they want to file a motion for to modify the child support regarding the child. But I don't necessarily think it has to be part of a court order.
And finally, Ms. Soto, you requested that the payments in the temporary orders be through Zelle. What is your client's position, and was it stated on the record, or what was stated on the record?
It was stated on the record because that had been what the parties had been doing in the past. He had been sending her $500 a month through Zelle before this petition was filed.
And did the court render or approve, or what did the court do?
Your Honor did verbalize that Zelle was approved.
Mr. Benavides' response, Mr. Rodriguez?
Yes, Judge, we did verbally agree, and I did confer with Ms. Soto, mistakenly thinking that the status quo would stay in place. But I mean, whatever the court orders, we could follow, Judge, but it is double the amounts of the previous payment. So that's the issue.
But what does that have to do with the payment method?
Well, that I'm just representing to the court. We agreed
On multiple things,
under the
one
false impression that-
thing being the amount. Understood. All right, Ms. Liendo, in your case with Mr. Benavides, the court finds that the true and correct agreed to amount is $1,101. The court will order, I'm not going to order it, I'm going to allow the inclusion of the HEROES program as an administrative guide, reference, or assistance to one or both parties with no judicial changes made by that inclusion. And the court will note that what was stated on the record, agreed to, and then rendered by the court for temporary orders was payment through Zelle. Those three things should be included as such in the temporary orders. Who will be preparing those?
Inaudible, all of it.
So Judge, I can prepare that, and Mr. Rodriguez can send me his Word document. I can incorporate his language on the HEROES program, but I did have one point of clarification. My order for temporary orders, we were here on March 31st, so I had the child support beginning April 1st. I just wanted to make sure that that's on the record, that it's as of April 1st, not as of today.
Right, so it's whatever happened on the day of. I mean, even if the court at this time were to find that something at that point was done incorrectly, and I'm not making that finding now, but you have to enter in whatever orders were pronounced and rendered, and then you modify from there. So if what was stated on the record at that time and approved was Zelle and April 1st, then that's what should be prepared now.
That's all I had, Your Honor.
Anything else on this case, Mr.
Yes,
Rodriguez?
Judge, there's another issue of visitation. So they requested supervised visitation at Sacred Heart. All we're requesting that the court order a minimum amount of visitations. It's been said that they have their own schedule. I just want to make sure that the grandparents, the paternal grandparents, are able to visit at least once a week, at the very least. The court could order that.
And Judge, I do have that in my order, and I did speak with Safe Haven and with Mr. Rodriguez. It will be at least once a week. They can't guarantee any more than once a week. And I also verified that maybe 2 or 3 people can go at the most in case one of the aunts or uncles wants to attend. We have no problem with that. But I can't guarantee, and Safe Haven can guarantee more than one visit a week, but it will definitely be at least once a week.
Well, I see the situation. So just if it's agreed to and not objected to, then put it in the court order, and then Mr. Rodriguez then come back at the final pretrial on June the 16th and at the final hearing on July the 28th and tell the court if those visits happened, and if they weren't allowed to happen, is it that attributable to Ms. Liendo or to the facility?
Yes, Judge.
All right. Anything else from any person?
And one final thing of allowing the biweekly payments, Judge, of child support. I believe that
I mean, as long as the full amount is paid, you all are doing something a little bit different for temporary orders, which is fine.
Yep.
But yeah, work with each other as long as that full amount is paid every month. It can be every week, every other
Yes.
week. Ms. Soto, these temporary orders are due to the court before that, before June the 15th. You're coming back on the 16th, so just get them in before the 15th.
Yes. Thank you, Judge.
All right, I wish you all well. Good to see
Thank you.
everyone.
Thank you.
That is all for Ms. Soto.
Thank you.
Good to see you, Ms. Soto. Good to see you, Mr. Rodriguez.
Next case, Attorney Ernesto Cavazos, page 7, number 19.
Filiberto Flores III versus Stacy Alexandra Hine, cause number 2026 FLC 641C3. Court marks Mr. Cavazos present in person. Jose Arce, are you present? Court marks Mr. Arce not present. Court marks Mr. Joshua Schamberger present by video conference. He's here on behalf of the Attorney General's office. Speaking to the microphone and to the court, are you Stacy Hine?
Yes, Your Honor.
Welcome to court, Ms. Hine. The court marks you present in person. The person to your left is your lawyer. Are you Filiberto Flores III?
Yes, Your Honor.
Welcome to court, Mr. Flores. Court marks you present in person. This is a second setting for temporary orders. Mr. Cavazos?
Correct, Your Honor. I've been conferring with Jose Arce since yesterday. He's in County Court of Law 1, and he's gonna come up here in just a few minutes, and we're gonna finish conferring if it's all right with the court.
Sure. Without knowing anything else, Mr. Flores and Ms. Hine, you have the first contested matter on today's docket. All right. Good luck.
Thank you, Your Honor.
Yes, sir.
Next case, Attorney Adriana Maddox, page 3, number 7.
This is Veronica Ann Rubio versus Juan Flores Lavoy, cause number 2021 FLA 1771C3. Good afternoon, Ms. Maddox.
Good afternoon, Judge.
Court marks you present in person. Oscar Vela, are you present?
Yes, Judge. Good afternoon.
Good afternoon, Mr. Vela. Court marks you present, participating by video conference. Ms. Rubio, Mr. Lavoy, any other parties or any parties present? All right, court notes no.
I am.
Court marks Ms. Rubio present and participating by video conference. Welcome to court. As you can see from your device, your lawyer is also present and participating by video conference. One more time, Juan Lavoy, are you present? All right, court marks Mr. Lavoy not present. Ms. Maddox, Mr. Vela, go ahead.
Judge, I had filed a motion for temporary orders, but I've conferred with Ms. Maddox this morning. I've agreed to drop the temporary orders request, and I am requesting a final hearing in 60 days, Judge, so that me and Ms. Maddox can exchange information and come for a final hearing.
Ms. Maddox,
That's the agreement, Judge, yes.
60 days before the beginning of the school year, Ms. Flores. So give us early to mid-August.
August 13th at 2 p.m.
Any objection, Mr. Vela?
No, Judge.
Ms. Maddox?
No.
All right, Ms. Rubio, I wish both you and Mr. Lavoy well. Have a great day.
Thank you, Judge. Have a great day. Thank you, Ms. Maddox.
Thank you.
Any other cases for either counsel?
That is all, Your Honor.
Good to see you both.
To may be
Thank you.
excused?
Yes, yes.
Next case, Attorney Daniel Walter, page 3, number 6.
Bernardo Trad versus Noemi Trad, cause number 2021 FLA 1036C3. Court marks Mr. Walter present in person, Mrs. Cotto present by video conference. Good afternoon to both.
Good afternoon, Judge. Nice to see you.
Good to see you and Mr. Walter. Mr. Trad, Ms. Trad, any parties present? Court marks no parties present. This is a, we're here for temporary orders, child custody evaluation, appointment of a guardian ad litem. Mr. Walter, Mrs. Cotto?
Judge, I sent Madeline Escoto for Miss Galliano now, Judge. And I apologize to Mr. Walter today, Judge. I've just been stuck in court since last week, and I had not been able to send him an offer of settlement. I sent him one today, based on the fact that he had just sent me his client's pay stubs and W-2. And for that reason, I don't think that Mr. Walter has a response on that offer today.
Not today, Judge, not yet, but I think we should be able to work the temporary orders and the other motions out very shortly. Maybe a short reset.
Sure. Ms. Flores, give us a temporary order setting, please.
June 16th at 2 p.m.
and give us a final hearing in late July or August, whatever's first available.
July the 30th at 2 p.m.
Any objection to any of those dates, Mr. Walter?
No objection.
Mrs. Cotto?
No, that should be fine, Judge. I have a vacation letter, but I should be back on the 29th. But if there's an issue, I will contact Mr. Walter.
I'm sorry, Ms. Flores, you said July the 30th
At 2 p.m.
all right, give me 1 second,
And the 16th at what time, Judge?
2 p.m. as well.
Yeah.
You know, I'm seeing that there's at least one unsigned, I'm assuming nobody's moving on the evaluation or the guardian ad litem requests?
No, Judge, because I think pending his response on that proposal, we're trying to alleviate some of the expenses for the parties. And then if we can't agree, then I'll urge my motions, because those were mine, on June 16th.
Right, the only, then the only pending and unsigned order is a motion to substitute. Any objection to the substitution, Ms. Cotto?
No, Judge.
Court has signed that order intending the original to the clerk's office. All right. I'll call this case on the 16th. Good luck to all.
Thank you, Judge. And that's all I have. May I be excused?
It's good to see you and good to see
Yes,
you as
please.
well.
Thank you, Judge.
Thank you, Your Honor.
Next case, Attorney Eduardo Romero, page 5, number 13.
Ana Cecilia Cisneros Villarreal versus Eduardo Villarreal, cause number 2026 FLA 158C3. Court marks Mr. Romero present in person. Good afternoon, counsel.
Good afternoon, Your Honor.
Ana Cecilia Villarreal, Eduardo Villarreal. Any parties present?
I don't believe they're present, Your Honor.
Court marks neither party present. Mr. Romero?
Your Honor, I was asked by both parties to request an additional 30 days for them to attempt to reconcile.
Well taken. 30 days puts us at the end of July, at the beginning of July. I tell you what, Ms. Flores, see how the summer plays out for the parties. Give us a setting in late July, early August.
July the 30th at 2 p.m.
Any objection, Mr. Romero?
No, Your Honor.
All right, we'll come back on July the 30th at 2 p.m. Good luck to both.
Okay, thank you, Your Honor.
Any other cases for Mr. Romero?
That is all for Mr. Romero.
Good to see you, counsel.
Likewise, Your Honor.
Next case is Attorney Melissa Saldaña. Page 1, number 2.
Rogelio Saucedo Jr. versus Naila Guerra, Ernesto Guerra, cause number 2016 CVG 1382C3. Court marks Ms. Saldaña present in person. Mr. Temes, are you present?
He's outside.
Court marks Mr. Joshua Schamberger present by video conference on behalf of the Attorney General's office. Speak into the microphone and tell the court, are you Naila Guerra?
Yes.
Welcome to Court, Ms. Guerra. Court marks you present in person. Person to your right is your lawyer, Ernesto Guerra, Rogelio Saucedo. Any other parties present? Court marks neither of the other parties present. Mr. Temes is present in person. Good afternoon, Ms. Saldaña, Mr. Temes.
We're conferring, so we're still, I think, in the process of conferring.
We are, Your Honor. I got an offer this morning. I've been discussing that offer with my client. I think we're set for a motion to show cause that was reset originally. But right now I'm just talking with my client about this offer and we're going over some of it.
All right, well, without knowing anything else, this will be the second contested matter on today's docket. So good luck as you confer. First question I'll be asking, because I know you are conferring, I won't ask that, but on May the 5th, I think there was an agreement to mediate with Judge Hale. So that'll be the first question I ask when y'all come back.
Okay.
Good luck to all.
Thank you.
Thank you. Next case, Your Honor, is Attorney Ruben Arce, page 2, numbers 4 and 5.
Sir, companion case is Vanessa Medina versus Aizar Coronado Medina Jr., cause number 2021 FLA 1017C3 and 2026 FLA 26C3. Court marks Mr. Arce present in person, Ms. Anderson present participating by video conference. Good afternoon to both.
Good afternoon, Judge. Brenda Anderson for Aizar Medina.
Ms.
Judge for Miss Vanessa, Your Honor, if we could believe that
Ms. Mina has limited English.
Say it again.
We just need the
Interpreter.
services of interpreter, Judge.
Speak into the microphone and tell the court, are you Vanessa Medina?
Yeah.
Welcome to court, Ms. Medina. Court marks you present in person. The person to your right is your lawyer. Aizar Medina Jr., are you present? Court marks Mr. Medina not present. Mr. Arce, Ms. Anderson, what is the announcement?
Judge, I filed a motion for continuance in this case today. I did confer with Mr. Arce about it yesterday. The children in this case started attending counseling. Ever since the parties separated, my client has been unable to visit with the girls because there's just been issues with the girls wanting to see dad. So they started counseling. I would like for my client to also participate in the counseling so that the counselor could try to get to the bottom of whatever is going on. So I do think that we need to just at least have the counselor talk to my client as well, so that we can just get an idea of what issues are, or what's happening, or what's making the girls not want to see dad. And also after their divorce in 2022 ordered that the house was awarded to both parties. Now, Miss Medina has moved out, and the decree states that either they sell the home or, I think the decree states that the house needs to be sold. I don't remember if it states whether my client could buy her share out, but he's trying to seek financing to be able to buy her share. So then we also needed time to try to resolve that issue as well and avoid having to do an enforcement of property division. So those are the two things, Judge, that are kind of pending. And that's why we just needed a bit more time to try to resolve all issues.
So I guess before I hear a response from Mr. Arce, Ms. Anderson, any estimate as to how long, how many days, how many months counseling should last?
I think that maybe we should just get a reset for 60 days and get an idea as to, because we can probably put in orders if additional counseling is necessary. We could put that in the final orders, but we'll have enough time to just get an idea as to how big the issue is and how it could be addressed, so that we could just put that language in the order.
Understood, Mr. Arce.
Yes, sure. Judge, myself and Ms. Anderson have been trying to resolve a lot of the issues that have popped up in this case, Judge. One of the main issues has been that visitation, Judge. We were addressing it through the counseling at Lifehouse. I did speak to one of the child's counselors, Judge, and without kind of injecting any information, too much information, this is what I had discussed with Ms. Anderson, is that there was still a ways to go as far as the counseling, Judge, as per the counselor having a recommendation for the court towards any visitation, Judge. And of course, when it's difficult, I asked the counselor for some possible time, and of course, as she explained to me, it's a case-by-case matter. So I think the 60 days wouldn't be out of the realm to try to get some resolution, Judge. We are both actively working to get all matters resolved in this matter, Judge. So I think that would be in the best interest of the children at this point, Judge.
All right. Anything else, Ms. Anderson?
Yeah.
All right.
And as we were contemplating asking for an ad litem because of the issues that have popped up with the children, but we're hoping that through counseling, any of those issues will be resolved, Judge.
All right. The request is for 60 days. It is well taken, granted for all of the reasons stated in the motion and stated on the record. Ms. Flores, give us that setting, please.
August 11th at 2 p.m.
All right. That is on the modification in the 1017 case. Ms. the clerk's office on the 2026 26C3 case. Has a non-suit been filed?
No, Your Honor, that issue still is still pending, Your Honor.
I thought that Ms. Anderson said on March the 5th in open court that a non-suit would be filed.
Yes, sir. I believe that after that we had stated that that's still an issue that we feel that if not being able to come to a resolution, Judge, we would still bring up with the court as far as the new union being formed, Judge. And myself and Ms. Anderson had spoken about that, Judge, to see if possibly if we can't come to a resolution on that issue, that we would just have a hearing on that particular issue, whether there's a new marriage that's viable and we provide proof to the court, Judge.
Ms. Anderson?
It's true, Judge. Originally, that was the plan to non-suit, but apparently Ms. Medina insists that a new marriage was formed, and this is something that my client disputes. They got divorced in 2022, and the divorce decree anticipated them remaining living together. And so we don't believe that a new marriage was formed just by continuing to live together, because the decree stipulated that they were going to continue to live together. But it seems like Mr. Arce's client refuses to non-suit it, so we may have to argue that issue if we don't resolve it in by the next court date.
And Judge, we'll provide documentation to Ms. Anderson to support our position, Judge, and if that's not sufficient, then we would just ask that we have a hearing.
No, it's actually part of the court record. That's what you all said. Yes, second time the court called the case, both lawyers were present, and you all said it would be non-suited. Let me ask you this, I guess this is Miss Medina's, right, this is Miss Medina's claim. There's only two things that we're going to do as part of that divorce. Number one is conservatorship, access, and possession, and that is already taken care of in the Sapser case, which is the original divorce. So then the question then, Mr. Arce, is your client requesting a division of property in the new filed divorce?
Judge, that is the issue, Judge, is that according to my client, that there was new property and or monies acquired during the new time that they were together, Judge. So that would lead us to file, that's what led us to file that new divorce action, Judge. So there was monies and property acquired as our position, Judge,
Sure,
from the time of divorce to the present date.
Sure, I can't, that may or may not be the case. In court, we'll have to hear evidence and testimony as to whether that claim is or is not supported. Very well. Then I will continue, the court will continue that case as well for August the 11th at 2 p.m. But at that time, on that issue, no matter what happens with the counseling, the court is going to hold a final hearing, and evidence should be presented one way or the other. If it isn't, then it'll be disposed of on that day, and then we'll proceed on to the child issues thereafter. Ms. Medina, do you have any questions for the court?
Solamente quería saber si después de cierto tiempo se considera matrimonio, aunque no estemos casados.
I'll explain that to her, Judge.
I just would like to know that if after a certain time being together, you're considered married.
I think your lawyer is going to provide you some advice as to what the court may or may not find. And talk to your lawyer, and Mr. Medina will do the same thing. I will call this case on August the 11th at 2 p.m. As you talk to your lawyer and he talks to Mr. Medina's lawyer, I wish both of you very well. Good luck.
Thank you.
Yeah,
Thank
that's
you,
all I have.
Judge.
It's good to see you.
I actually had another matter, but I believe that Your Honor had called it.
I think we did we not, Ms. Flores?
Yes, Your Honor, that was on page 1, number 1.
Yes, sir.
All right.
But I spoke to the opposing party, Judge, and I'll get that date.
Fantastic. Thank
Judge,
you,
that's
Mr.
all I have.
Arce.
No big excuse.
Good to see you.
Thank you, Judge.
Next case, Your Honor, is Attorney Julio Garcia, page 4, number 10.
Afternoon, Judge.
Good afternoon, Mr. Garcia. This is Maria de Los Angeles Mireles versus Jeronimo Ibarra, cause number 2025 FLB 1514C3. Court marks Mr. Garcia present in person. Mr. Figueroa, Luis Antonio Figueroa, are you present? Court marks Mr. Figueroa not present. Maria de Los Angeles Mireles, Jeronimo Ibarra. Any parties present? Court finds no parties present. Mr. Garcia?
Your Honor, I represent Mr. Ibarra and Mr. Figueroa and I have been discussing this matter quite extensively. We're actually set for mediation next week with Judge Hale. I think a couple of things that were lacking was just to get an appraisal on the house and the business. One is pending and the other one we're waiting, but we're hopeful that we can get this mediation done next week and be able to report to the court, hopefully with a successful mediation.
Sounds wonderful and fantastic. Good luck to all persons as you mediate with Judge Hale. If it's successful, just you can follow some orders before then.
Most definitely, Judge.
Any other cases for Mr. Garcia?
That is all for Mr. Garcia.
Good to see you, Mr. Garcia.
You too, Judge. May I be excused?
Yes, sir.
Thank you, Judge.
Next case is Attorney Mario Castillo, page 4, number 11.
Mario Alberto Valadez Jr. versus Jocelyn Ventura, cause number 2025 FLI 276C3. Court marks Mr. Castillo present in person. Mr. Villafranca, are you present? Court finds Mr. Villafranca not present. Jonathan Garcia Davalos, are you present? Court finds Mr. Garcia Davalos not present. Court marks Mr. Joshua Schramberger present and participating by video conference on behalf of the Attorney General's office. Mario Valadez, Jocelyn Ventura, any parties present? Court finds no parties are present. Mr. Castillo?
Good afternoon, Judge. We filed the agreed motion for continuance. The only issue pending is the issue of retroactive child support. I believe we're waiting for the amount, for the AG to give us the amount.
Okay, I see in my notes we have some pay stubs from 2024, but I don't see that there was an agreed upon date of separation and all that. And I don't think we have all the pay stubs for the relevant time periods because we only have some months, not all.
And that would be for father or mother?
I'll double check. That would be the father's wages, but it's not very much that we have.
And the father would be Mr. Castillo's client. What information would assist your office to do a true and correct calculation of child support?
So the agreed date of separation, if they agree, that way I know how many months to calculate. If he's got any other children aside from this case, and then to get the full pay periods, the full pay stubs or W-2s, tax returns, whatever it may be, for the relevant time period. Because all that I have right now is December of 2024.
I see.
I can get that information from my client, Judge.
How much time would be reasonable and necessary to transmit that information to the Attorney General's office?
I believe 30 days would suffice, Judge.
All right. Lourdes, give us a setting in 45 to 60 days.
July the 30th at 2 p.m.
Any objection to that date, Mr. Castillo?
No, that works, Judge.
Any objection, Mr. Schomburger?
No, Your Honor.
All right, I've signed an order for continuance. I've reset the case in that order for July the 30th, 2026 at 2 p.m. and I've written the following language. Mario Valadez is ordered to produce to the Attorney General's office the following information. 1, date of separation. 2, whether he is responsible financially for any other children. And 3, pay stubs for the relevant time period until the date of the hearing, due 30 days from this order. All right, I'll call this case on July the 30th. Good luck to all.
Thank you, Judge. May I be seated?
Yes, good to see you.
Next case, Your Honor, is Attorney Leticia Garcia, page 6, number 17.
Elizabeth Marino versus Jesus Antonio Chapa Cavazos, cause number 2026 FLA 694C3. Good afternoon, Ms. Garcia.
Good afternoon, Judge.
Court Martial present, you're participating by video conference. Is this Elizabeth Marino in your office?
It is, Judge.
Welcome to court, Ms. Marino. The court martial present by video conference from the office of your lawyer, Jesus Antonio Chapa Cavazos. Are you present? Court finds Mr. Cavazos is not present and court takes notice that he was served with process May the 6th, 2026. Ms. Garcia?
Your Honor, he actually came into the office and sat with my client and I, so we've got some agreed temporary orders. I do need an interpreter, Judge.
We'll begin Spanish language interpretation now. Go ahead.
If I can ask her some questions, Your Honor.
Ms. Marino, would you raise your right hand?
Señora Marino, ¿podría levantar su mano derecha, por favor?
Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
¿Usted jura que y afirma que el testimonio que va a dar en esta causa va a ser la verdad que la ayude Dios?
Sí, señor.
Yes, Your Honor.
You may lower your hand, Ms. Garcia.
Ya puede bajar su mano.
Ma'am, state your name for the record, please.
¿Me puede dar su nombre completo para la acta?
Elizabeth Albarrán Marino.
Elizabeth Albarrán Marino.
Ms. Albarrán, is it true that we sat with Mr. Chapa, your husband, and the following orders are agreed to between you and him, correct?
Señora, es cierto que usted y yo nos juntamos con el señor Chapa y las órdenes que voy a leer son correctas. ¿Es eso cierto?
Cierto.
True.
You're asking that you and he be appointed joint managing conservators of the 2 minor children, with you having the right to designate the primary residence, correct?
Usted está pidiendo que los dos sean conservadores de los dos menores y usted tenga el derecho de decir en dónde van a residir, dónde van a vivir ellos, ¿es correcto?
Sí.
Yes.
And child support will be set at $1,652 per month, beginning June 1st.
Y manutención va a ser $1,652 empezando en junio 1.
Sí.
Yes.
And he will be responsible for payment of the medical support of $30 per month, beginning June the 1st.
Y él va a pagar los gastos médicos de $30 empezando en junio 1.
Sí.
Yes.
And he will be awarded extended standard visitation with a 24-hour notice in advance of his days off as he comes into Laredo, as he is a CDL driver.
Y él se le van a dar visitas extendidas con un 24 horas, tiene que avisar 24 horas de anticipación cuando él llegue a Laredo, ya que él es chofer, ¿correcto?
Sí, correcto.
Yes, correct.
And you will have exclusive use and possession of the homestead located at 3509 Laredo Street, Apartment 1.
Y usted va a tener el uso exclusivo de la residencia ubicada en 3509 Laredo Street, ¿correcto?
Correct.
Correct.
And he will be responsible for payment of the household bills and rent in the approximate total of $800, also to begin June the 1st.
Y él va a pagar el alquiler y los gastos de la residencia, que son aproximadamente $800 empezando en junio 1.
Sí.
Yes.
And you will have exclusive use of the vehicle in your possession, which is a 2015 Chrysler 200.
Y usted va a tener el uso exclusivo del vehículo, un Chrysler 2015, Chrysler 200, 2015.
Sí.
Yes.
And he will be driving a 2015 Dodge Ram pickup, correct?
Y él se va a quedar con una camioneta Dodge Ram 2015.
Sí.
Yes.
And we're asking for the temporary injunction that's already been pled for, correct?
Y eso es adicional a la orden que se interpuso anteriormente.
Sí.
Yes.
That's all we've got, Your Honor, for temporary orders.
Es todo lo que tenemos para órdenes temporales.
The court hereby adopts and approves that agreement.
El juzgado aprueba el acuerdo
Court finds that at least for these temporary orders, they are in the best interest of the children.
y encuentra que las órdenes son en el mejor interés de los menores
These temporary orders are due to the court on or before
y esas órdenes temporales deben ser introducidas al juzgado
June 29 at noon by submission.
junio 29 a las 12.
Ms. Marino, do you have any questions for the court?
Señora Marino, ¿tiene usted alguna pregunta para el juzgado?
No.
No.
I wish you and Mr. Cavazos as well. More importantly, I wish your children all the best. Good luck to you.
Le deseo lo mejor a usted y al señor Cavazos y lo más importante, le deseo lo mejor a sus hijos. Que tenga un buen día.
Next case for Attorney Garcia, page 7, number 18.
Alfonso Hinojosa Jr. versus Erika Rubi Garcia, cause number 2026 FLC 106C3. Court marks Ms. Garcia present by video conference. Ms. Brenda Anderson also present by video conference. Mr. Joshua Schamberger is also present by video conference. He's here on behalf of the Attorney General's office. Alfonso Hinojosa, Erika Rubi Garcia. Any parties present? Court finds no parties are present. Ms. Garcia, Ms. Anderson?
Your Honor, I think we're still waiting for the results of the paternity exam from the Attorney General's office. They notified us late last week, that the results were not in yet and would not be in by today. Josh, I'm not sure whether by chance maybe yesterday.
I do think we have them. Let me double check.
There's a set of results on file from a prior testing, and that last name was Herrera. That's not this case.
Yeah,
This
I
case is
see
Hinojosa.
that the court filed an amended order on May the 5th before and in preparation for this docket. I re-reviewed the docket. I didn't see any docket entries, so I don't think if they are complete, I don't think they're on file. Mr. Schomburger, can you shed any light?
Yes, we did get them last week, it looks like. But the test was done for the child Brandon with Alfonso Hinojosa. They do not exclude him. We can go ahead and file that with the court so that it is on file. So he is the father.
Thank you.
All right,
Uh,
so go ahead.
I'm sorry, Mr. Schomburger, can you please send us an email of the results, of the positive results?
Yeah, let me make a note. I'll send you and Miss Anderson though.
Thank you.
Thank you. Thank you.
So knowing that you're going to have these results, you're going to need some time to review, then share them with your client, advise them each accordingly. Ms. Garcia, Ms. Anderson, how much time would be reasonable and necessary to prepare for a final hearing?
3-4
30,
weeks.
60?
Probably 30 days should suffice,
Yeah,
right?
30. My client does work out of town, Judge, so that's enough time for me to get him in.
All right, Ms. Flores, get us as close to 4 weeks or shortly thereafter as possible.
July 7th at 2 p.m.
Any objection to that, Ms. Garcia?
No, Your Honor.
Objections, Ms. Anderson?
No, Judge.
Mr. Schomburger?
Well, that's the week that we have our statewide meeting, Your Honor. If we can do after that, if possible, we'll be
Very
out that
next
whole
meeting
week.
after that, very next meeting after that, Ms. Flores.
So was it that meeting that within that week, or because the next available date is July the 9th?
No, it's the whole week. Sorry, it's the 6th through the 10th that we have a statewide meeting.
Next would be July the 28th at 2 p.m.
Any objection, Ms. Garcia?
None, Judge.
Ms. Anderson?
No, Your Honor.
Mr. Schomburger?
No, Your Honor, that works.
All right, so ordered. Good luck to all.
Thank you, Judge.
Next case from Ms. Garcia, page 7, number 20.
Carrie Christine Ochoa versus Robert Lee Zamora, cause number 2026 FLC 679C3. Court marks Ms. Garcia present and participating by video conference. Ms. Garcia, is this Carrie Ochoa in your office?
It is, Judge.
Welcome to court, Ms. Ochoa. The court marks you present. You're participating by video conference from the office of your lawyer. Robert Lee Zamora, are you present? Court marks Mr. Zamora not present in person, not present by video conference. Court takes judicial notice that he was served with process May 18th, 2026. Ms. Garcia?
Your Honor, if I can just have her sworn in, I just got a couple of questions for her.
Ms. Ochoa, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
You may lower your hand. Ms. Garcia, go ahead, but Ms. Ochoa, speak up as loud as possible so we can all hear you. Ms. Garcia, go ahead.
Ma'am, please state your full name for the record.
Carrie Christine Ochoa.
For temporary orders, you are here today requesting that you and Mr. Zamora be appointed joint parent managed conservators, with you having the right to designate the primary residence of the child, correct?
Yes.
With regards to child support, Your Honor, I'm going to waive that until the final hearing, only because I know that he just got employed by another company very recently, and I'd like to send discovery or a subpoena to his employer. Mr. Zamora is under protective order currently, Judge, and he has, not contacted my client for wanting to see the baby, and I that might be a reason why he is not here. But nevertheless, I will send a subpoena to his employer for the final. With regards to visitation, Ms. Ochoa, you'd like him to be able to visit with the baby who will be 2 years old next month, correct?
Correct.
And the supervising agent is a person who is Lizette Cisneros. She is a mutual friend of both of you all, correct?
Correct.
And in the orders, we will set out that he can contact Ms. Cisneros directly with at least a 24-hour advance notice after hours and on the weekends, correct?
Correct.
He can set up hours through her, and he can visit with the baby at her home. You will take the baby to Ms. Cisneros' home and then pick her up after the visit is over, correct?
Correct.
With regards to any communications between you and Mr. Zamora, you're asking that the app close co-parenting application be ordered, so that way you all can both communicate with regards to the baby's safety and welfare, correct?
Correct.
And given that you do have a protective order, you're asking for the temporary injunction in accordance with our pleadings, correct?
Yes.
Is there anything else?
No.
That's all I've got, Judge, for this one.
Ms. Ochoa, in your case, cause number 2026 FLC 679C3, the court finds that there is sufficient information in the record to permit the court to grant your request. The court finds that your requests are made in the best interest and are, in fact, in the best interest of the children in this case. When the court hereby grants your request in full, these are the temporary orders and temporary injunction ordered by the court. These orders are due to the court on or before.
June 29 at noon by submission.
And we'll come back for a final hearing about 4 to 6 weeks after that.
July the 30th at 2 p.m.
Any objections to that date, Ms. Garcia?
We're good, Judge. Thank you.
All right. Good luck to you, Mr. Zamora, and all involved. Have a good day, Mr. Ochoa.
Thank you, Your Honor. That being excused, I've got nothing further.
Good to see you. Yes, have a great day.
Have a good day, Judge.
Next case, Attorney Philip Del Rio, page 3, number 8.
Raylan Hernandez versus Martin Ramiro Maldonado III, cause number 2024 FLI 1859C3. Good afternoon, Mr. Del Rio.
Good afternoon, Your Honor.
Court martial present. You're participating by video conference. Oscar Peña, are you present? Court finds Mr. Peña not present. Mr. Joshua Schamberger is present by video conference. He's here on behalf of the Attorney General's office. Raylan Hernandez, Martin Maldonado. Any parties present? Court finds neither party is present by video conference or in person. Mr. Del Rio, we're here for entry of judgment.
So, Your Honor, yes. I have submitted an order from what I recall, and my notes reflect from what you ordered at the last hearing. Mr. Peña submitted the same. I could not let, I guess the issue is, Your Honor, for you to see which order was, I guess, more appropriate to what you had instructed on the bench. And that's kind of where we're at. And Your Honor, really the only 2 pages that are in contention after reviewing both is page 2 and 3 and 4 with regards to the language for visitation, and then with regards to the child support.
So the whole purpose of an entry of judgment, so normally we do orders due, and they're done by submission because there is no disagreement. If there's an entry of judgment, that indicates to the court that there could be some disagreement and necessity for the court to consider whatever needs to be thought of before signing one of the orders, let me ask the clerk's office, together or after the filing of these proposed orders to modify, was anything filed with the court?
No, Your Honor.
So no memorandums of law, no notices, advisories, motions to reconsider, nothing filed after the proposed orders?
No, Your Honor.
So this can only be done by argument. Mr. Del Rio, tell the court what is on pages 2, 3, and 4. What are the differences and what is your client's position?
Well, Your Honor, the differences with regards very minor. The location of where the exchanges would occur, they also had San Antonio, but Your Honor had specifically said all the exchanges will occur in Washington State. Essentially, my client has the right to choose how to control his visitation. This was the case where Your Honor had said travel is good for children, and he wanted, Your Honor said, my client has to make the arrangements to visit the children, but he's got to go up there to visit with the kids. And then the only other thing, Your Honor, is just that you specifically said once Ray Leonidas establishes residence in Texas, then the tile support shall increase to this 1060 where it's currently at. Mr. Peña added some language with regards to calculating the percentage of income, and this was the offset for the travel. It just wasn't said that way, Your Honor. And so it's a little bit of a surpluses, and that's essentially it, Your Honor. The differences are relatively minor, but they are different. And so our position is our language is correct and it's concise and it's exactly what Your Honor ordered.
So I understand the argument as to the second, because this court would never order a non-specific amount because it's contingent on something else. In other words, if there is the necessity for recalculation, then it has to get proven and then ordered. So I understand that. I think you prevail on that point. It's very consistent with what this court would do. Crystallize the. So this court said that the visits would be. I remember that the court saying that travel in this day and age is in children's best interests. But remind the court what the court said as to where the visit should take place, what your position is, and what Mr. Peña's position is.
So, Your Honor, our position was that you had said the pickup and drop off of the children for the visit of my client shall be at the Washington State Airport, and the drop off time shall be no later than 10 p.m. of the posted flight. They wanted to add the location in San Antonio, which that wasn't ever addressed or said, Your Honor. Let's see. The other issue was.
As to that, I guess before we move on, it sounds like, but it sounds like that would benefit your client, would it not?
Well, I mean, I'm trying to actually get a copy of Mr. Peña's order. I don't know what happened to it, Judge. I don't think he actually. I guess he filed it. I'm assuming he filed it.
I have it here. What page would that be on?
I apologize, Judge. I don't know what the heck happened with it.
On page 3, he listed the pickup and drop off times should be no later than 10 p.m. of the posted flight. And
I don't even see a copy of it anymore.
But I think your number 3 and his number 3, both on page 3.
I don't see where that is ordered.
I think it says the exact same thing, except that you actually state the Washington State Airport, and he says SEA plus AC. I can only presume those are call signs for 2 different airports.
Yeah, and I don't know. I don't know what he presumes by that. Like I said, they're minor, just so I don't know why. I think the issue, Your Honor, was that none of the other parties wanted to sign. The others coming from the other side, essentially. That's kind of what I'm getting. That's sort of the concern here. Oh, and also, I think one of the issues was he put the child's home is Washington State, but jurisdiction was not raised, and establishing residence, Your Honor clearly said you had continuing jurisdiction of this case. That was on his. I'm not sure where. And then they removed the provision that says that I have complete control over the visit. My client has complete control over his visits. They wanted to say that father is responsible for all travel expenses, and that is true, but Your Honor says specifically my client controls when he visits. And so again, I understand they seem sort of minor and trivial, Your Honor, but this has been one of those cases where they're just adamant about what you said on the bench and what is reflected on paper.
All right, thank you. So now, that's all the testimony you're presenting to your record now. So now we're gonna go to close. So Ms. Carson. Yes, Carmen, I give you this minute for the evidence.
I think this readjustment or clarification would solve the issue. I've signed your order, Mr. Del Rio, but I've modified the exchange location language to say pickup and drop off for the children for visits with Martin Maldonado shall be at an airport in Washington State, comma, unless agreed to otherwise by the parties in writing prior to purchasing flights.
Very good, Judge. Perfect. I think
I've
that makes a lot of sense.
I've signed your order and I'm tendering the original to the clerk's office, and that resolves this case. Anything else on this matter?
No, Judge, thankfully not. Thank you.
All right. Any other cases for Mr. Del Rio?
That is all for Mr. Del Rio.
Have a great day, counsel.
Thank you, Judge. You too.
Next case, Attorney Brenda Anderson, page 5, number 14.
Jessica Marie Fernandez versus Ramiro Alonso Fernandez, cause number 2026 FLA 330C3. Good afternoon, Ms. Anderson.
Good afternoon, Judge. Brenda Anderson, present for petitioner Jessica Marie Fernandez.
Court marks you present and participating by video conference. Jessica Fernandez, are you present? Court finds
don't
Ms.
think so.
Fernandez not present. Court takes judicial notice that Mr. Fernandez, although he was served with process on May 21st of this year, that wasn't filed until yesterday. That being the case, announcement?
So we do need time, Judge, for him to respond. So we could get a setting in possibly, I would say 45 days. I may need to send him some discovery. But it may not be, I mean, I think 45, maybe 45 days for a pretrial setting. And then a final hearing date, maybe 15 days after that.
I think that would be good. Ms. Flores, give us a final pretrial hearing and give us a close to date to 45.
Yes, sir. That'll be July the 28th at 2 p.m.
Then give us a final hearing about 2 to 4 weeks after that.
September 1st at 2 p.m.
Any objections to those dates, Ms. Anderson?
No, Judge.
All right, good luck.
Thank you. I have one more case.
That's on page 6, number 15.
This is Glenda Sosa versus Alfredo Hernandez, cause number 2026 FLA 360C3. Court marks Ms. Anderson present and participating by video conference. Glenda Sosa, Alfredo Sanchez. Any parties present? Court finds neither parties present. Ms. Anderson?
Yes. Okay, my client is present, Judge.
Are you Glenda Sosa?
Sí.
Court marks you present participating by video conference.
Participando por videoconferencia.
Alfredo Hernandez, are you present?
Alfredo Hernández, ¿está presente?
Court marks Mr. Hernandez not present in person, not present by video conference.
El excusado marca al señor Hernández no se encuentra aquí por videoconferencia o en persona.
Court takes judicial notice that he was served with process March 18th, 2026.
El juzgado toma notificación que él recibió notificaciones marzo 18 del 2026.
Ms. Anderson?
Señor Anderson.
Your Honor, this is her first setting, and I think I have the same announcement in this case where I may need to serve husband with discovery. So if we could have this possibly the same dates, Judge.
Es el mismo anuncio que el anterior. Quisiera más tiempo para poder entregar, si es que encuentro que hay necesidad de entregarle documentos al esposo.
Without objection, go ahead, Ms. Flores, give us those dates, please.
Señora Flores, si no hay ninguna objeción, denos esa fecha.
Final pretrial, July the 28th at 2 p.m. And final hearing, September the 1st at 2 p.m.
La audiencia inicial va a ser julio 28 a las 2 p.m. y la audiencia final va a ser septiembre 1 a las 2 p.m.
Ms. Sosa, keep in contact with your lawyer
Señora Sosa, manténgase en contacto con su abogada
and call your case on July the 28th.
y voy a llamar su caso en julio 28.
Do you have any questions for the court?
¿Tiene alguna pregunta para el juzgado?
No.
No.
All right, you're excused. Have a good day. Any other cases for Ms. Anderson?
Ya se puede retirar, que tenga buen día.
That is all for Ms. Anderson.
Have a good day, Ms. Anderson. It's good to see you.
Thank you, Judge. You too.
Next case, Attorney Valerie Cortinas Fisher, page 2, number 3.
Good
Edgar
afternoon, Your Honor.
Alejandro Cobos versus Stephanie Selena Gonzalez, cause number 2020 FLI 1799C3. Good afternoon, Ms. Fisher.
Good afternoon, Judge.
Court martial present, you're participating by video conference. Good afternoon, Ms. Garza.
Good afternoon, Judge.
Good afternoon. You're joining us by video conference as well. Court marks Mr. Joshua Schamberger present and participating by video conference. He's here on behalf of the Attorney General's office. Ms. Gonzalez, unmute your device and tell the court, are you Stephanie Selena Gonzalez?
Sí.
Let's begin Spanish language interpretation. Are you Stephanie Selena Gonzalez?
¿Es usted Stephanie Selena González?
Sí.
Yes.
Welcome to court. The court marks you present by video conference.
Bienvenida al juzgado. El juzgado la marca presente por medio de videoconferencia.
As you can see and hear from your device, your lawyer is also present and participating by video conference.
Como puede ver en su aparato, su abogada también está presente por videoconferencia.
Edgar Alejandro Cobos, are you present?
Edgar
He's not
Alejandro
here.
Cobos no se encuentra presente.
Court marks Mr. Cobos not present.
El juzgado marca al señor Cobos no presente.
Ms. Fisher, Ms. Garza, we have a motion to dismiss, a motion to modify, and a motion to withdraw.
Señora Fisher, tenemos una orden de retiro del caso, una orden de sustitución de abogados y una orden de modificación.
We'll begin with Ms. Fisher.
Vamos a
Thank you.
empezar con la señora Fisher. Gracias.
Thank you, Your Honor. I just spoke with Mr. Copos today, and he is not opposed to opposing counsel's motion to dismiss for want of prosecution this matter. And if that is the case and the court does grant opposing counsel's motion for such, there would be no need for my motion to withdraw, Judge, and that would just be waived as well.
Yo me comuniqué con el señor Cobos y él está de acuerdo en desestimar el caso y eso tomaría el efecto de los demás cosas que están pendientes del juzgado sobre la sustitución de abogado.
Ms. Garza?
Yes,
Señora
Judge,
Garza.
we are not in objection to that announcement.
No tenemos ninguna objeción a ese anuncio.
Court is granting the order of dismissal.
El juzgado está cediendo la orden, aprobando la orden de retiro.
Let me just ask the clerk's office, the request for dismissal is a dismissal of the Sapser suit.
Déjame le pregunto a la secretaria, ¿es petición de retiro del caso del SAPSE?
I think it's a modification, Your Honor.
Right, the
There's a-
dismissal of the modification.
Es un retiro de la modificación, su señoría.
Let me ask the clerk's office, is specific language required to solely dismiss the modification request without dismissing the entire case?
Déjame le pregunto al juzgado, ¿es necesario hacer una orden específicamente con la solicitud de modificación?
Your Honor, I'm
If
not.
it helps,
I'm
Your
not-
Honor, I know that they normally ask us when we non-suit our case to put the motion filed and the date it was filed. So that way that specific motion is closed in their system.
En nuestro sistema se nos pide que pongamos la fecha específica y la ponemos ahí y ahí aparece la fecha específica en la que se hizo la modificación.
The court has signed the order of dismissal
El juzgado ha firmado la orden de estimación
and has included language that says the petition to modify filed on February 10th, 2026 is hereby dismissed.
y ha puesto lenguaje específico que la petición solicitada en febrero 26 ha sido estimada.
Any objection to any of this, Ms. Fisher?
¿Alguna objeción?
No
señor?
objection, Your Honor.
No hay ninguna objeción, su señoría.
Ms. Garza?
Señora Garza.
objection, Judge.
Ninguna objeción.
Mr. Schomburger?
Señor Schomburg. No, su señoría.
Tendering the original signed order to the clerk's office.
Acabo de entregar la orden firmada, la orden original firmada por la
wish-
Secretaría del Condado.
I wish all parties in council well. Good to see you all.
Les
Thank
deseo a
you,
todas las
Judge.
partes lo mejor.
Bye. Thank you.
Next case, Attorney Jose Salvador Reyes, page 6, number 16.
Karen Martinez versus Cruz Molina, cause number 2026 FLA 683C3. Court marks Mr. Reyes present in person. Good afternoon, counsel.
Good afternoon, Your Honor. Ms. Karen Martinez is present in the courtroom, and Mr. Cruz Molina is present, but he is unrepresented.
Ms. Martinez, speak into the microphone and tell the court, are you Karen Martinez?
Yes, Your Honor.
Welcome to court, Ms. Martinez. Court marks you present in person. The person to your right is your lawyer. Mr. Molina, speak into the microphone and tell the court, are you Cruz Molina?
Yes, it's me.
Welcome to court. The court marks you present in person. Mr. Molina, do you have a lawyer?
No, because of the short time I was notified and because of my work, I'm requesting more time so I can hire one.
Mr. Reyes?
Well, number one, Mr. Molina was served on or about May 8th of 2026. Today is June the 2nd, more than 23 days, which is more than the time permitted for him to respond to the petition. But if that's the case, I'll leave it up to the court's discretion. We would ask that the court just extend a temporary restraining order and advise Mr. Molina not to be communicating with my client through the children and putting them in the middle of a battle that does not pertain to them. That it behooves him that if he doesn't hire a lawyer, he's free to communicate with me, which I offered to speak with him before the hearing today, and he was very rude to me. Although I can deal with that, I'm a big boy, but it doesn't bother me. It's not my battle.
Mr. Molina, what is your email address?
May I just advise the court that Mr. Molina, from what I understand, speaks English perfectly. He works for an agency that requires him to speak English. Second of all, I'm asking the court to advise Mr. Molina that he should provide his current address to us so we know where the welfare and best safekeeping of the girls will be. So we're offering him visitation if he would agree to it. However, we need to know where he resides.
Email address ELLAS_SONASI@hotmail.com.
One more time for the record.
ELLAS_SONASI@hotmail.com.
I'm not going to comment on your email address because it's in Spanish. But I know what that means. Mr. Molina, keep in contact and in the lookout with your email, because if the court needs to send you any information or notices, that's where that information is going to go. Same thing for Mr. Reyes. If he needs to send you any information and any requests, then it's going to go to that email address. I'm going to reschedule this because this is the first setting for a temporary orders hearing on,
June 18th at 9 a.m.
all right, so I'm going to give you, the court gives you more time to look for a lawyer, to talk to a lawyer, and to hire a lawyer. But you need to do that as soon as possible, because if you wait till a day, 2 or 3, 4 days before, that isn't going to be enough time for someone to learn your case, hear you out, provide you legal advice, and to prepare for that hearing. So do it as soon as possible. Between now and then, these temporary orders or this temporary restraining order is extended. So both you, Mr. Molina and Ms. Martinez, need to keep the peace, not talk to the children about the case at all. Do you understand all of this?
Yes.
Do you have any questions for the court, Mr. Molina?
I have the proof of when I was notified, and it's not the same day that he's saying.
Understood. Do you have any questions for the court?
No.
Anything else on this case, Mr. Diaz?
Court want me to request to discover.
Inaudible.
Address, will the court want me to request his current address for discovery, or is he obligated to give it to us now if he wishes to exercise visitation? My client has not been denying him visitation. However, he's instructed the two children, which are under the age of 17, not to tell the mother where they're staying with the father.
Mr. Molina, do you have any objection to telling Ms. Martinez your place of residence for purposes of knowing where your children will visit when they're in your possession?
No, I have none.
What is that residence?
One 1702 Belgian Blue Loop, Laredo, Texas.
One more time.
1702 Belgian Blue Loop.
All right. Anything else on this case, Mr. Diaz?
Belgian, as in the country Belgium.
Inaudible.
If he can spell it, I would appreciate Belgium being spelled.
Belgian.
Okay, Blue Loop, thank you.
Anything else on this case, Mr. Diaz?
No, Your Honor.
Ms. Martinez, do you have any questions?
No, Your Honor.
Ms. Flores?
Yes, Your Honor. Would this be a hybrid hearing or an in-person?
Let me make sure that everybody's here in person on this case.
And
All right.
June 19 at 1 o'clock.
At 9 a.m. Ms. Martinez, Mr. Molina, I wish you both well. Have a great day.
Thank you very much, Your Honor. Have a good afternoon.
Good to see you, Mr. Diaz.
Recall case, Your Honor. It'll be Attorney Ernesto Cavazos, page 7, number 19.
Filiberto Flores III versus Stacy Alexandra Hine, cause number 2026 FLC 641C3. Court marks Mr. Arce present in person, Mr. Cavazos present in person, Mr. Flores is present in person, Ms. Hine is present in person. Mr. Arce, what is the announcement? Excuse me, Mr. Cavazos, what is the announcement?
Thank you, Judge. We have an agreement and we need to announce it to the court, but I need to wait for Mr. Arce to come back. He's here somewhere with his client.
Yes, the
deputy will look for him.
all right, we'll place this case on hold momentarily.
Okay.
Your Honor, if I can, I'm present on this case as well. Joshua Shamrock with the Attorney General's office.
We'll mark you present by video conference. Thank you.
Yes, Your Honor.
And the next case is a recall case, Your Honor, as well. I don't see the attorney on page 1, number 2.
Rogelio Saucedo Jr. versus Naila Guerra, Ernesto Guerra, cause number 2016 CVG 1382C3. Court marks Mr. Tamez present in person, Ms. Aldana present in person, Ms. Naila Guerra present in person.
Your Honor, Joshua Shamrock also on this case, yes.
The parties are conferring on all cases. Other than those two cases, have all other cases been called?
Yes, Your Honor.
And call one, page 4, case 9, Yadira Salvador, Enrique Salvador, cause number 2025 FLA 1446C3. Court marks no persons are, well. Olivero Canales, Jose Luis Castillo, Yadira Salvador, Enrique Salvador. Any parties present? Court finds no parties, no lawyers are present. There is a motion for continuance. The court had received it before this hearing. The court signed off on it. This case is reset for July the 7th at 2 p.m. All right, no parties are ready. We'll stand at ease.
Oh,
Please be seated. Good afternoon. Court is back in session and we are back on the record on this family law docket for Tuesday, June 2nd, 2026. The time is now 4:05. First case on recall is page 7, case 19, Filiberto Flores III versus Stacy Alexandra Hine, cause number 2026 FLC 641C3. Court marks Mr. Arce present in person, Mr. Cavazos present in person, Mr. Joshua Schamberger present by video conference. The parties are both present in person. They are Filiberto Flores III and Stacy Alexandra Hine. Counsel, what is the announcement?
We have an agreement, Your Honor. And I can read it into the record whenever the court is ready.
Yes, sir. Go ahead.
Judge, that we've agreed to join managing conservator with my client, Mrs. Stacy Hine, being the person that can designate the primary residence of both children. Child support to be set at $300.50 a month, starting with this Friday, to be paid to Mrs. Hine. And then from then on, every month on July on the first of the month. Visitation is going to be standard the first, third, and fifth weekend of every month. And they're going to pick up the child on Fridays on the day that he gets the children at 7 p.m. at night and return him Sunday at 7 p.m. at night. And they're going to try to work through the app close, some kind of app, so they can talk to each other. Mr. Arce is going to give me the information. Also, that we've agreed to join temporary orders to be granted against both parties. And we're going to also work on having electronic communications when they don't have the children other days. But for now, we have Saturday at 6:30 p.m. every Saturday at 6:30 FaceTime. And then we have two other issues that we're going to leave for the final hearing, the retroactive child support and the geographical restrictions. Also, Judge, we're asking the court to give us another month to August for the final hearing so I can be able to do some discovery about the income. And I can ask my client.
We just get your confirmation, Mr. Arce.
If I may, just a couple of points to clarify. Just one, because we are before the court on temporary orders. Of course, Judge, the agreement before the court is just on a temporary basis. So again, the parties have agreed that they be named as temporary joint managing conservators, with with the respondent having the temporary right to designate the primary residence of both children. Visitation standard, again, just temporary. Support, Judge, was going to be at $300.50 beginning June 5th, this Friday. That's going to be paid by having Mr. Flores provide money orders to the respondent, Ms. Hine. We did agree, Judge, with regards to any kind of communication between the parties being done through the app codes. As far as medical insurance, my understanding, Your Honor, that the children are presently on Medicaid, so there's going to be a reimbursement from the petitioner, Mr. Flores, to the state. And I guess, I don't know, we maybe might need the help of the state, Mr. Schamberger, in this matter. We'd want to keep that at a minimum, Your Honor. I don't know, possibly maybe something like $50 per month. We also did agree, Judge, that there be some added access by both parties with regards to FaceTiming on Saturdays at the time that was mentioned by Mr. Cavazos. And I believe, Judge, pickup and drop off will take place at the residence of the respondent, Ms. Hine, and that address is 5710 Alabama Circle, here in Laredo, Texas. And I want to say, Judge, that just about covers it.
Mr. Flores, Ms. Hine, would you raise your right hands? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God? Both have answered yes. You may lower your hand. Speak into the microphone as the lawyers ask you questions. Mr. Cavazos, you may proceed.
Can you please state your name for the record? Right here.
Sorry, Stacy Hine.
Stacy, you've heard the agreement as I read it into the record, and as Mr. Arce also read it into record. Are you in agreement?
Yes, sir.
Do you believe that that's in the best interest of your children for the judge to grant that agreement?
Yes, sir.
Okay, I pass them.
Cross-examination, Mr. Arce.
No questions, Your Honor, but I do have some questions of Mr. Flores.
Questions for Ms. Hine, Mr. Schomburger?
No, Your Honor, just to clarify, I think I heard Mr. Arce say 50 per month on the cash medical. We're fine with that and having it with the same effective date as the child support. So just to clarify that.
All right, Mr. Arce.
That's fine, Judge, if I may, Mr. Flores, good afternoon. Can you state for the court, please?
Inaudible.
Your full name for the court, please, Mr. Flores?
Filiberto Flores, the
Okay.
third.
And Mr. Flores, you are the party who filed this matter before the court. You are the petitioner in this matter, is that correct?
Yes, sir.
And we're talking about two minor children before the court. Your sons, what are their names?
Emiliano Luis Flores and Aurelio Flores. Flores.
And how old are they, Mr.? Yeah, they're twins.
Yes.
And how old are they?
4.
Okay. Now, Mr. Flores, you also heard the agreement as was read into the record by both Mr. Cavazos and myself as well. Are you asking the court to accept that agreement?
Yes, sir.
Okay. Do you have any questions with regards to the agreement?
No, sir.
And do you believe that the agreement is in fact in the best interest of the children, Mr. Flores?
Yes, sir.
Okay. Any questions?
No, sir.
I'll pass on this.
Questions for Mr. Flores, Mr. Cavazos?
No questions at this time.
Mr. Schomburger?
No questions, Your Honor.
Anything else before the court approves?
No.
No, Your Honor.
Ms. Flores, Ms. Hine, in your case, cause number 2026 FLC 641C3, the court has now heard the agreement, and you have stated under oath that that is your agreement. The court hereby adopts and approves your agreement, finds that that agreement is in your two children's best interest. These now become orders of the court that are due to the court on or before
June 29 at noon by submission.
And the request was for an August setting. Any objections to that, Mr. Cavazos?
That's correct, Judge. We were asking, I believe, August the
11th.
11th, if
At 2
possible,
at 2
Judge,
p.m.
if possible.
Do we have that date, Ms. Flores?
I
Yes,
think that's
Your Honor.
advanced family law seminar, Your Honor. I don't know if courts take going to that.
I missed that. Say it again, Mr. Schomburger?
I think that's the week of advanced family. I'm not sure if the court is going to that.
I would love to. I keep wanting to go every year and every year work.
Or we can do it at a later date, whatever is acceptable to the court.
It's not on my calendar. So let me ask you this. Will you be there, Mr. Schomburger?
No, they don't send us to advanced family, so we'll be working that week. But
All right.
I know that week is advanced family, Your Honor, just because of our dockets.
As a matter of fact, I must be here. I have an interview with a child at 1. So go ahead and set it for that day, Ms. Flores.
Thank you.
August 11 at 2 p.m.
Thank you.
Mr. Flores, Ms. Hine, keep in contact with your lawyers. I wish you both very well. More importantly, I wish your two sons all the best. Have a great day.
Thank you. Have a good day.
Mr. Cavazos, Mr. Arce, good to see you both.
Thank you, Your Honor. Same here. May I be excused?
Yes, sir.
Thank you.
That leaves one case on the court's docket. Rogelio Saucedo Jr. versus Naila Guerra, Ernesto Guerra, cause number 2016, CVG 1382C3. Court marks Mr. Tamez present in person, Ms. Alania present in person, Ms. Guerra present in person, Mr. Schomburger present by video conference. He's here on behalf of the Attorney General's office. Speak into the microphone and tell the court, are you Rogelio Saucedo?
Yes, Your Honor.
Welcome to court, Mr. Saucedo. Court marks you present in person. One more time, Ernesto Guerra, are you present? Court finds Mr. Guerra not present. Mr. Tamez, Ms. Alania, go ahead.
Your Honor, Mr. Tamez, for the record, I represent Mr. Saucedo. Judge, the parties have been going back and forth on a settlement. I think we've reached an agreement that we would like to announce to the court in open record, in which counsel and I will further document through a settlement agreement. But if I could, Judge, and with counsel's corrections as I go along, if I can read that into the record. Judge, the parties have agreed to settle their claims, the mutual claims that they have with against each other in this particular modification, and also a case that was filed by the respondents in the 406. And we'll get to that in a second. Judge, part of the agreement is as follows. The condo that is the subject of this pursuant to this modification or this enforcement action is going to be sold. The condo will be sold as is. The listing agreement will be entered into by the parties within 1 week of today. The listing agreement will state that there will be no credits for any repairs that will be given. The listing agreement will be for 1 year. The parties have already mutually agreed to the realtor, and that will be Miss Martha Wright. The realtor will set forth after market analysis the price. The price may be lowered by the realtor based on the realtor's recommendations every 6 months. The parties will accept any offer that's within 10% of the asking price. The parties will be allowed 1 week before we enter into this listing agreement to exchange written offers to purchase a condo. So before we get into this contractual obligation with the listing agent, the parties may exchange offers between each other to buy each other out pursuant to the obligations and liabilities that exist on the condo. Similarly, Judge, when the listing agreement ends, the parties will be given a grace period of a week to exchange offers once again. So the parties can take a look at the condition of the mortgage balance and exchange offers to buy each other out. Part of the agreement, Judge, is that there is a ancillary AG child support case pending downstairs. There will be no child support owed. The only obligation that Mr. Rogelio Salcedo will need to pay is any medical expenses that the AG is requiring that the AG would be reimbursed. There will be a mutual release of all claims, past, present, and future, that will be signed by all parties. The 406 lawsuit, Judge, is this other lawsuit that the respondents filed that will be non-suited with prejudice. Both parties or all parties will incur the court costs and the attorney's fees that they have incurred. While the condo is listed and under the listing agreement, Judge, the parties agree to pay that mortgage 50-50. Ms. Guerra will give my client Rogelio Salcedo the information so he can make payments directly to the mortgage provider. The realtor will decide what utilities, if any, need to be made available or paid on the condo. If it's the light, my client will pay for that utility, and that cost, I guess, will be split
50-50.
50-50. That is, I believe, the extent of what I believe. Counsel, did I leave anything out or?
So yes, so my client would give Mr. Salcedo the mortgage bill so that he could pay it directly, his half, and my client would pay the mortgage directly to the bank. As far as the light, that's correct. It would be paid 50-50 if the realtor requires the light, and if the light would be under Mr. Salcedo's name. If the realtor requires water, then that would be under Ms. Nyla Guerra's name. And again, those would pay 50-50, and each would exchange bills so that they could pay the agency directly. The payment of the mortgage shall begin June 2026. And that's correct, non-suit. So Mr. Salcedo shall non-suit his enforcement, any pleadings and all pleadings that he has, so that, again, this case is completely closed. And no claim shall be requested after today. Oh yeah, Mr. Salcedo will be given access to the condo so that he can go in. As far as the proceeds, it's going to be split 50-50. Yeah, after the mortgage is paid and closing costs, correct?
And one other thing, Judge, Ms. Guerra and Mr. Guerra will not make any claims for any credits for past repairs or modifications to it.
Correct.
I believe that's it.
Your Honor, if I may,
Sure.
I think this whole thing got started when we filed our motion for enforcement. Obviously, we've not conferred on any of this. So did y'all discuss how our motion for enforcement would be handled? Since there's not been payments in a while?
Well, I think, and maybe you can shed some light on this, Mr. Schomburger. There is a medical portion of your petition that cannot be waived. Is that correct?
Correct. And so I just like having teeth to collect since there's been no payment in a number of years. So I'm fine with the deferred commitment if you're agreeable to that. And I have the pay record I can submit to the court. And I'm fine with mom releasing what's ever owed to her. But just so that I have.
What's the
So
balance of medical?
the balance of the medical is $2,770.71. And I can prepare an exhibit with the release of the child support so that it's a zero judgment as of yesterday. And then that judgment for the medical. The interest on that is about $13. So we would request a payment of $63 per month beginning July 1st. But I just want to have teeth to the order because I did file a motion for enforcement. So I do want to make sure that.
Let me ask you this before we get off on tangents, and I agree that none of this matters unless you agree to that. However, for my purposes, that's something different because as I understand it, we're here not on Mr. Schomburger's motion because it sounds to the court, but it doesn't sound, it reads to the court based on the court's review of the file that the AG's request is sent before Judge Mendez on July the 15th, 2026. This is the property law enforcement. So it sounds like, and you can tell me, Mr. Tamés, Ms. Saldaña, and Mr. Schomburger, if this is incorrect, but it sounds like the parties to extinguish or resolve this claim will enter into, if approved by the court, into the settlement agreement that'll convert into a final order or a judgment, then you would take that to Judge Mendez and then make whatever argument you need to make with Judge Mendez.
That seems fair to me, Judge. We can paper this within a week and present it to the parties, and if the court agrees to enter some kind of final judgment.
Yeah.
Right. So
Your Honor, I'm not opposed to that. So if they want to enter into a final order related to the property division, and then my motion is reserved for July 15th on all issues, that's perfectly fine by me.
Well, it's a global settlement. So we're asking the court to approve the global settlement, not piecemeal it, and have to take this to Judge Mendez to have her approve that part.
Oh, and that's what I was getting at. We can do that if y'all agree with what you want, what I want on my motion.
I don't understand what you want on your motion. Your motion is not pending today. We can take it up on July 15th, but we're going to ask the judge that she approves this agreement.
That's
Well, I
correct.
mean, but again, I'm a necessary party to this, so I have to piecemeal it or deal with it today.
Well,
Because I'm thinking that if we just.
here's the court's concern, Mr. Schomburger, and I don't disagree with you at all. However, I'm hesitant if there is a pending action with Judge Mendez that this court somehow do something without even notice or advising her that we're about to do that. It sounds like if the parties have resolved the property law issue, I can prove it or not, and then they can put in orders, and that leaves your motion pending. And not that I won't hear it now, but I just don't want to take it out of Title IV if that's what's pending.
And I'm fine with that, Judge. Like I said earlier, if we do an order solely related to the property division and all of my issues are reserved for the July 15th, I can do that. But they're kind of wanting to, and this was one problem I had with the case, they're wanting to conflate the property division with the child support, and they're separate issues. So, because they're kind of dealing with some of it, but not all of it. You see what I'm saying, Judge? That's
sort of. So if I'm understanding, I had identified that, I just didn't make a hay of it because it's not going to be for me to resolve. But it sounds like, counsel, so it sounds like the parties have an agreement that this court can approve and put into an order that resolves the claims here. But then you need to go back to the Title IV court and say, all right, so there's this pending request by the Attorney General's office and this agreed to order regarding the property. And then Judge Mendez needs to hear whatever she needs to hear so that she can resolve anything that's pending with her. She may agree with Mr. Schomburger that something that's left pending, or she may say the parties are contractually bound to this and or not. I don't know. That makes sense.
I understand what the court's getting at, but like I said, their orders kind of combining the two issues, but they're not fully resolving my issues.
I don't disagree. You're not a signatory to this agreement.
Okay.
Let me ask, so look, I don't want to relitigate this in a month. So if Mr. Schomburger can articulate what are his concerns, so we can address them in a mediated settlement agreement between the parties, so we address everything. I don't want Mr. Schomburger to show up a month from now and say, well, this doesn't pertain to me, and nix an agreement that the parties have worked very long and hard to come up with. So Mr. Schomburger, what issue do you have that is left outstanding after hearing this agreement?
The contempt portion for the medical support. I just want teeth to the order. So a deferred commitment says that he would be sentenced to jail, and if he doesn't pay what he's supposed to pay, we can enforce that because there's been no payment for a long time. And I don't want him to go to jail. I want him to pay. And if he's going to pay what he's promising to pay, then he's never going to set foot in jail.
Can we just make a reference to the OAG case in our agreement here and then go to Title IV and then have an order over there?
Yeah, council and I were discussing that right now, Judge, and we can certainly take it up on July 15th. But what I said is, if that's Mr. Schomburger's only issue, I think we can address it on July 15th. That'll give the parties enough ability to enter into the agreement that we work to resolve, and then we can certainly take those issues up with Judge Mendes then.
I think that's right.
Yeah.
All right. Mr. Salcedo, Ms. Guerra, would you raise your right hands? Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
You may lower your hands. Is your true and correct name Rogelio Salcedo Jr.?
Yes.
Mr. Salcedo, did you hear the agreement that was told to the court by the lawyers?
Yes.
Is that your agreement with Ms. Guerra?
Yes.
Is that your full agreement?
Yes.
Was anything left out?
Yes. No.
Is there anything you want to change?
No.
And we didn't touch on any child. Yeah, we did. Do you believe that this agreement is in the best interest of your children?
Yes.
Same questions to you, Ms. Guerra. Is your true and correct name Naila Guerra? Did you hear the agreement that was told to the court by the lawyers?
Did.
Is that your agreement with Mr. Salcedo?
It is.
Is that your full agreement? Was anything left out? Is there anything you want to change?
No.
Do you believe that this agreement is in the best interest of your children?
Yes.
Mr. Damas, any questions for any parties?
The only, with regard to the prove up, we do have one party that's not here. But counsel has said that he is in agreement, and as the officer of the court, and I guess as legal counsel for Mr. Guerra, that he also approves the term. Is that correct?
Correct. Yes.
Any questions for any parties, Ms. Alaya?
No.
Mr. Schomburger, any questions for any other parties?
No, just to clarify that for purposes of the record, my motion for enforcement by contempt is reserved for July 15th.
Yes, ostensibly for Judge Mendes to hear and consider whatever evidence and testimony you present and whatever evidence, testimony, and order results from this agreement. Yes. Any questions for the parties, Mr. Schomburger?
No.
All right. Mr. Salcedo, Ms. Guerra, the court hereby adopts and approves your agreement in full, finds that it is in the best interest of the children. These orders are due to the court honor before
June 29th at noon by submission.
You have any questions for the court, Mr. Salcedo? Court has heard no. Any questions for the court, Ms. Guerra?
No.
The court has heard no. All right. I wish you both well. Congratulations on resolving this. I know it's been a long journey, but you're almost near the end. So you can expect to sign off on, I can expect to sign off on these orders very soon. I wish you both very well and your children as well. Have a great day.
Thank you very much, Your Honor, for your time.
Good to see you, Mr. Tamez. Good to see you, Ms. Saldana. Good to see you, Mr. Schomburger.
May I be excused?
Yes. Ms. Flores, have all cases been called on today's docket?
Yes, Your Honor, all cases have been called.
This now concludes this docket held in person and by video conference for Tuesday, June 2nd, 2026, the court continues to embrace the latest technology to provide safe and uninterrupted access to justice without delay. Today's docket was made possible by the appearance of counsel and parties and by the assistance, diligence, and preparation of the Webb County Court at Law 2 staff and the employees of Webb County that provide judicial support to the court. The court